Hundreds of Basuki Tjahaja Purnama supporters have been flocking the Jakarta High Court Cempaka Putih Central Jakarta to demand his immediate release on bail. The supporters says they will stand firm outside the High Court building until their request is fulfilled, despite warning from authorities to disperse themselves at 6 p.m. Police are forcing the supporters by disperse by means of water cannons, but supporters are determined to stay until their request is fulfilled. You are still with Indonesia Highlights and a dialogue with University of Indonesia lecturer Togi Pangaribuan about legal aspects surrounding the conviction of a public servant, and in this case is former Governor Basuki Tjahaja Purnama. So, Togi, what do you think is other legal aspects in Basuki's case that most of the public probably do not compare?
I think currently what's urgently needs to be understand is the mechanism of detention and suspension of detention or bail.
Oh, okay.
Now, first of all, the detention comes from a ruling that forms part of the decision handed down to Pak Basuki. Now, there are many debates, and I can assure you each have their own merits, but we have to see detention under Indonesian criminal justice system as part of an investigation. We have to see that the Indonesian criminal code, in conferring the rights for a judge to provide detention, that the right attaches to the purpose of the detention. The purpose of a detention is for an investigation. The criminal procedural code specifically states that the authority for a criminal court judge to issue a ruling on detention is for the purposes of an investigation
about the case.
Correct. Right. Now, theoretically, once the prosecutor issues a charging letter or a surat tuntutan, the Indonesian criminal procedural code specifies that the investigation has ceased. It has stopped. So you can argue that the district court judges did not have authority to issue a ruling on detention. This is affirmed through Supreme Court letter number 8 of 85 that says that if a district court judge does not have the authority to conduct a detention, then a detention cannot be done, and a ruling on detention cannot be done with a decision. Now that's one. That's the issue of detention, and how it's odd that a ruling for detention is passed. But having said that, a ruling on detention has been done. Pak Basuki is currently in Mako Brimob in Depok. So what can we do? So people out there have been talking about issuing or being part of a suspension of a detention atau penangguhan penahanan. Now, the thing that needs to be understand is that for a suspension, or first of all, a detention has time limits. So Pak Basuki is not going to be there forever. There are time limits. The time limit at most that it can be extended is 90 days.
90 days?
90 days. So at most, Pak Basuki can only be detained for 90 days. That's one. Two, can Basuki's detention be suspended, or can it be moved or altered into a house arrest or a house detention or a city detention? Of course, the criminal procedural code provides avenues for this. You can apply for a suspension of detention.
Suspension of detention.
Penangguhan penahanan. Now, a suspension of detention under the Indonesian criminal procedural code has 3 requirements. and they're very simple. The first one is that there is a request for suspension or detention. The second one, the authority having the institution, be it the prosecutor, be it the judge, in this case the judge, in Pak Basuki's case the judge, approves of the request for suspension of detention. And the third one, the accused, Pak Basuki, the defendant, Pak Basuki, agrees to comply with all the terms of a suspension of detention. Now, a request for suspension of detention can also be attached with a guarantee in the form of a person, jaminan orang, or a guarantee in the form of money, jaminan uang, or a combination of the two.
Okay.
Now, the thing is, if we fulfilled all of these requirements, the number one deciding factor is whether or not the judge, in this case the judge has the authority for the suspension of detention of Pak Basuki, is whether or not the judge grants the request for suspension of detention. Now, the Indonesian Criminal Procedural Code regulates that the consideration for granting a suspension of detention is based on issues listed out in Article 21 of the Criminal Procedural Code, which is whether or not the judge has any worry that the defendant will run away or escape, that the defendant will destroy or alter evidence, and third, whether or not the defendant will repeat the same crime. Now, these are all very subjective.
Yes.
There is no objective parameter. These are all very subjective. These are all very based on intuition, hunch, and personal assessment of the judge. So there is no objective threshold. For example, if the number of people guaranteeing for Pak Basuki suspension detention reach 10,000 or reach 5,000, or there's a limit of the amount of bail money. If you post 50,000, 500 million rupiah or 1 billion rupiah, then the detention can be suspended. There is no parameter like that, unlike in other countries. So the issue is, I see, and this has to be applauded because it reflects or demonstrates the spirit of solidarity and willingness to care of the people. They're lining up to provide a copy of their identification cards to be listed as people that are willing to guarantee for Pak Basuki's detention suspension. However, despite this noble effort, in the eyes of the law, actually this doesn't matter.
Okay.
As you can see, there is no threshold of the number of people joining in to guarantee Pak Basuki. There is no threshold of the amount of money that must be posted or must be transferred for Pak Basuki to be released from detention. Now, this all goes down to whether or not the judge, in this case the High Court judges, sees Pak Basuki as having the risk to do all the three things that I've already mentioned: running away, altering evidence, or repeating the crime. Now, given that one of the considerations of the district court judges is that Pak Basuki has repeated these things, these actions, through his book and through the Wi-Fi in his office, there is a very likely chance that the High Court judges would think that Pak Basuki will repeat the same crime. Again, this is pure speculation from my side. But you can
really
see
subjective.
that. Correct. As you can see that these three criteria, their fulfillment are also very subjective. So you see that it all depends on how the person is, how the judge sees it.
How they sees it.
Correct. So I think these two are the legal aspects that people need to understand.
Okay, thank you. Togi, it's getting more interesting, but
thank you.
We will continue more after the break.